Hi, good afternoon, everyone. We are so excited to be here for yet another webinar featured by the Curry Law Firm, and super excited to join our fabulous founding attorney this week to be able to talk to you all about trademarks and specifically the Trademark Takedown. So today we are going to be tag teaming this subject to be able to give you some valuable information so that you can really have some tools in your toolkit, your legal toolkit that is, to be able to protect and enforce your brand and the rights that come with it. Anything you want to add?
Well, I came to her with this topic because she does an amazing job with doing trademarks, but lots of times people just don't understand it and they think that you have to have an established brand to invest in your trademark. And then when they do have a brand that's established, they get really bad news. So it's our goal to, one, encourage you to take preliminary steps to make sure you're doing a good job for your business, but also make you aware that it's not like a zero sum game where if you delay, if you get it later, you wait until you're successful, that it's easy just to pick up the ball and start running at that time. Some of these things are super time sensitive, and unfortunately, not all trademarks are successful. So just because you submit your application, it doesn't mean that it'll go through. So you want to know that as soon as possible.
Exactly. So we'll definitely be going through a lot of these topics today and giving you more information about what it means to be able to enforce those rights and speak on what she was saying and speak on a little bit about what I said we would talk about as well. So let's get started. So why do trademarks actually matter? A lot of times, especially with our clients, I feel like our established clients are like, I've already been in business. I've never had any issues. Why do I need to get a trademark now? And I'll give you an example of a client we were just dealing with who has been in business probably about a little over 10 years and recently received a cease and desist letter stating that they needed to immediately stop using their name. Now, in their industry, their name would be connected to industry specific licenses. And if they change their business name, they're going to need to reapply for all of the business licenses that they have. And that can be very costly. And people don't necessarily know this new brand or this new name that they're going to have to come out with. And so it ended up just being very costly. They're an established business, never had any issues until now. So why does a trademark matter? Your brand is literally your most valuable asset. Like, how many times do we go to Google or Yelp to look up a specific business name or a company to see what those reviews are that are connected to that specific business? Part of your brand is the experience that you offer, the name, your logo, what people think about or see when they hear your business name or logo, and how they feel based on the experience from the products or services that you offer. Another thing is that copycats can steal sales, reputation, and trust overnight. So if someone else is coming out and saying, that they are essentially your brand or a very similar name, it's confusing consumers. They could be taking some of your sales. People could literally think that they're going to get the same experience or the same quality of product or service, and they're not even getting that from you. For another person, one of my classmates actually, who's an attorney, she constantly has copycats making pages stating that they're an attorney and they're offering legal services, and they're sending DMs to people asking them for money. And sometimes these people are sending money to these fake pages thinking that they're going to get legal services, and they're not actually getting any services from that person. And it diminishes her legal reputation because it's not her at all. It's simply a copycat. And then another thing is that protecting it is protecting your future. So as I stated, this client of ours who had been in business for about 10 years, if she or he would have simply taken steps in the beginning to really protect their brand, they would have been protecting their future so that in the future, they're not dealing with the matter that they have been addressed with at this point.
I want to add one thing when it comes to the valuation of your trademark, because when it comes to your balance sheet and when it's time to sell that business and hopefully walk away with a lot of money because of your efforts to build that business, one of the ways that you can move from just the money on the books, just taking an EBITDA and saying, what valuation can we do based off of your cash flow? You having an established brand and established trademark goes on as intellectual property. It can lead to your balance sheet and it can explain an increase in the valuation of your business. So it has some real dollars that can be attached to it.
And that can be valuable in the beginning or even in your growth period where you're trying to get investors. Even on Shark Tank, there have been instances where the sharks have asked the specific creative who's in front of them, do you have a trademark for this, right? And in one instance, I saw a video, this person was able to establish that they did have a trademark registered and tell the investors what the value of that specific trademark was, so that when they are trying to get investors and investors are determining, well, how much should I invest into this? How much of a risk is it? Being able to see that they have a registered trademark increases the value. And in another instance where we help a lot of clients with, which would be business dissolutions, when you're trying to, like you said, value the business, that definitely goes into it. And people don't necessarily think about it. They may be looking at the dollar amount in the business bank account, but no, the brand that you have built up with sweat equity, time, and money is definitely something that holds value as well. So with today's talk, we definitely want you to be able to understand more benefits of a trademark, how to file a trademark application, how to enforce your rights, and what to do when you receive a cease and desist letter, or even how to send a cease and desist letter yourself. And so some quick statistics that I found, a 2019 report showed that 83% of brands experienced trademark infringement that year in 2019. Like, that's a high number. So to think that, like, oh, well, nobody has ever tried to steal my brand. What if you just don't know about it? You know, like, being able to be online and on the internet and social media is so helpful in building our brand and expanding our brand, but it's also exposing us. And so we need to be mindful of that. Another statistic was that in 2023, individuals impersonating business 30,000 cases of fraud reported to the FTC. So that is an extraordinarily high number as well, is that it almost goes into the example I was telling you all in the beginning about someone posing to be a business and ruining their reputation, and really being fraudulent with what they're doing. They're taking money and not offering the service or the product that they said they were going to offer.
And that can also lead to like bad Google reviews. So it doesn't have to be just monetary fraud. When you're stealing someone's reputation, they may say, hey, a company with this name did defraud me or never gave me services, and then it can be difficult to get it off of Google.
Absolutely. Absolutely. So what exactly does a trademark protect? And that is a great question, because sometimes people get trademarks, copyrights, and patents confused. So let's specifically just focus on trademarks and what they protect. A trademark is really meant to protect a brand and how consumers relate what it is that your specific service or product is to your business name or your logo or your slogan. So I have an example off to the side, which is Nike. When we hear the word Nike, typically we're thinking of athletic products such as tennis shoes or athletic apparel, and we're thinking of their slogan, just do it. You may think about like some of those black and white commercials where there's an athlete like running and working hard. They're really putting in the necessary work and effort to get to a successful goal in their specific sport. And so that's really what a brand is. What is that name that people hear and they automatically think of the service or product you offer? Or they hear the slogan, just do it, and you're like, that's Nike. You see a tennis shoe and it has a swoosh symbol on the side of it. You know that is a Nike shoe. And so you can protect your business name, your slogan, your product name, such as Air Max or Air Force One or Dunks, right? Like, those are all product names that Nike has registered with the trademark office, as well as their logo. So when you're thinking about a trademark, think about your brand. What do people think about when they see or they hear your brand? And those are the types of items that you're going to be able to protect with a trademark. Common myths about trademarks. So we hear these a lot too, especially in our initial consult.
A lot.
And the first one, an LLC protects my brand name. But I don't know about you, but I hear not just an LLC, but like a DBA or an assumed name, people think will protect their business name. Do you have those stories as well?
All the time, people say, well, I registered an LLC. And even if you did in your state, and you can't get a state trademark, you may not have nationally.
And so that is an important thing to know about as well. Domain names do not equal trademark rights. How many times, and I had this with a client and I was like, hey, I don't think we should proceed forward with this trademark application. I don't think it's going to go through. They're like, I've had the domain name for 2 years. The domain name doesn't equal trademark rights. Sometimes people will have a specific name or logo trademark, but that doesn't mean that they have the domain for that, but that does not diminish the rights that they have based on the rights that the trademark gives them. The other myth is that first use is enough, right? So it's not just if you're the first to use it, but if you're the first to use it and first to register it. Someone else can actually register the mark that you are wanting to use, and they'll have priority rights over you. Sometimes there is a little window where you may be able to take over those rights if somebody did trademark a name that you had been using before them, but it's costly. I mean, you're looking at spending thousands of dollars in expenses with the trademark office to petition to get that trademark canceled, and then hiring an attorney to be able to represent you in that matter, and then time, right? So you could be losing sales or be losing any sort of like business revenue because it's now taking time to get that other mark canceled, when if you would have just filed for yours in the beginning, you would have had the rights to that protection.
And it's the uncertainty too. As a business owner, that can be one of the scariest things. You're going to dump a lot of time, a lot of money into making sure you have your logo all together and designed, and your bags printed, and your brand consistency, and maybe putting a sign outside of your door. And that fight, even if you feel like, well, I was first, sometimes you get into the details. You may have be the first public notice, but they may have private operations that you could not see, that you did not know about, that makes them first in time. So it's a big gamble when you say, well, I'm first in time, because it's just, you only know what you know. And there may be information out there that proves you're not.
Right, right. And then the truth is that registration is literally the strongest legal protection, because if you have that registration with the United States Patent and Trademark Office, that can hold up in court. It can hold up to get things done immediately, such as having a domain name removed from somebody who's using it in the same way that you would be able to use it and using your registered mark, or being able to have things taken off of social media that would infringe on your rights. So why is registration essential? Well, there are many things that it can help, such as national protection. Now, there are two types of protection, and Eleanor did kind of hint on it a little bit. There is a state trademark and there is a federal trademark. But the trademark that we are literally preaching about and what we only help our clients with are going to be federal trademarks that are filed with the United States Patent and Trademark Office. That gives you national protection in all 50 states. A state trademark will only give you protection in that one state that you register the mark in. And that isn't really that useful, especially where we're in this day and age where you could be getting customers who are in Canada or who are, on the other side of the country from where you are, because the internet makes things so accessible to people's fingertips. The trademark can also request infringing use to be removed from the internet, which I just talked about. It's easier to license, franchise, or sell your business.
Yeah.
And it provides stronger enforcement rights in court. Like, I don't know if you've ever watched Judge Judy, but Judge Judy always wants to know what is in writing. What is in writing? What is on paper? And a United States Patent and Trademark Office registration is on file with them in their national database. And it's an actual certificate that you get. Like, it's a paper proof that you are the owner and you have ownership rights to this specific mark. So how do you actually monitor for infringement? And I think that's a great thing to hint on, because once clients come to us about registering their actual mark and getting the protection, we do send a letter to them afterwards or an email letting them know, like, hey, there are things that you need to be doing on your own to uphold this right that you now have. But some of the things that you can do would be to set Google alerts and web monitoring. And I usually tell my clients, maybe make it a habit on every 2 to 3 months, go through social media and look up different handles or hashtags and see if anyone is using your specific brand name that you've trademarked for the same or similar services you offer, right? Like, someone else could have the same name, but they're in a completely different industry, and that's okay. That's not infringing on your use. What you're looking for is if they're using it in a way that can confuse consumers about who is the true offerer of those specific services or products, to the name that you have trademarked. Social media scans, like I just talked about, Amazon and e-commerce searches, go through Amazon. Are there any other names of companies that are out there? Sometimes through Amazon, you'll have like Chinese stores that may have a name that you're using here. And that wouldn't show up on the trademark database, but it would show up in Amazon, and you can definitely tell them. Amazon has what's called a brand registry. And so they are looking for consumers. Well, I shouldn't say consumers, but marketplace holders who actually have the trademark registration. So some of our clients who offer product, like tangible products that they sell on Amazon, we have to let Amazon legal team know, yes, there either is a pending trademark application or we have actually registered this trademark and they do have the trademark rights for this, because Amazon does not want to be in any sort of trademark infringement battle. They're not going to be, you have someone saying that they allowed for this trademark infringement. They don't want any parts. They want to make sure that people have actual ownership to the brand that they hold themselves out to be the owner of. And the last thing is USPTO watch services. So you can sign up on the USPTO website to get alerts if there's any sort of applications that come through that may be in your specific industry, or someone is trying to trademark the specific name or a similar name that you've already trademarked. And so at that time, if you get any of those alerts, then you could possibly oppose those trademark applications at the appropriate time if the USPTO doesn't already flag it for likelihood of confusion. And with the USPTO watch services, you can do it yourself or you can hire outside companies that offer those services. So red flags of infringement. Constantly be on the lookout for infringers. Like with social media giving you broader audience for marketing, it's also giving you a broader audience for possible infringers. So some of the things to look for will be similar logos or names popping up, suspiciously low cost lookalike products. I think we've all seen those. Like I've seen them for the ice machine. I don't know about you, but I love the ice at like Chick-fil-A and Sonic. And I'll see these ice machines for like $5. That just doesn't make any sense, right? Those ice machines market for about $200. So if there's anything suspiciously low cost, like for a lookalike product, that's typically a scam. And you really want to look for things that confuse consumers are contacting you about. So even some of our clients who unfortunately have received cease and desist letters, part of the reason that the other company found out about them is that there was a confused customer saying, I thought that was your business. You know, are you affiliated with this business at all? You know, we were so confused. And now they're contacting our clients saying, hey, you need to stop using this mark because it's infringing on our clients' rights. And we actually have customers that have been confused, and that's no good at all, especially if you end up going to court for that. Yeah. And someone is saying that they have customers that were confused. You don't want that. And then if you have a drop in sales without any sort of explanation, you know, you've been on a trajectory where you're moving upward and then all of a sudden there's a steep drop, you may want to start to do some searches for possible infringement to see if there are other pages out there posing as your business and who are possibly like usurping your sales and they're not going to your business. So trademark takedowns. Trademark takedowns fall under at least 5 main areas that we're going to discuss today. And that includes platform takedowns, cease and desist letters, further legal options such as lawsuits or injunctions, domain name removal, and then actual lawsuits themselves. And so obtaining the trademark is the first step, but actually enforcing the protection is going to be the second step. So I'll hand it over to you.
And I'll actually give a step 0. Even if you are not ready to trademark the name, go search the trademark name. I recently started rolling on an idea. This is such a good idea. And then when I went to go look at the trademark, and it's not available. So even if just know beforehand that the business name that you intend, someone has already earmarked, especially if it's in your category. So, and the categories are based off of services, based off of products. And so if it's already there, it already exists, there's no way around it, maybe just choose from the beginning a new business name. And it'll save yourself a lot of time and worry and going backwards when you're trying to go forward in your business. So if you have either had a trademark and are trying to send out a cease and desist because you found some of those infringers on the internet or a business that is operating similar to you, or you receive one, it can be a devastating step. Now, if you're enforcing infringement, it's costly. You're retaining an attorney, you're trying to enforce, you're trying to make sure someone carries through with what they need to do to stop that infringement. And if you're on the receiving side, that may mean your whole brand has to change. It can be a rude awakening, especially for people who say, hey, I have an LLC, so I'm protected. Or lots of people, you never heard of the business. You may be a Texas business and it may be a New York registration. And so you say, well, how could that be a confusion? Because they're so different than me. We're in completely different states. We don't have the same customers. And that may be your thought, but that may not be the thought of the other party or the trademark office. So just because you don't see the connection doesn't mean a connection can't be made, and you can be forced to stop using something. And that's really what a cease and desist letter is. It's a precursor to litigation. It's just put somebody on notice. Hey, we've seen this name. We think that there's similarities that concern us. If you're giving it or receiving it, and you need to either stop or consult with an attorney to see how you can proceed, what's the safest way to go forward. Now, sometimes maybe they haven't been using it and they may agree to sell their trademark, or they may agree that you can coexist and have some sign off to what your particular verbiage is or your name is. But oftentimes, especially once you're at the cease and desist letter, they're not interested in that type of negotiation. They just want you to stop, and that can have consequences. And certainly if you are sending a cease and desist, you can understand you work hard to build your brand, you work hard to infuse your own, personality and your own level of quality and importance into that brand. And you don't want someone coming and saying, we both call it Gidget Widget, but I've spent $100 making mine and you spent 1 cent making yours. That's going to be a very different product, and it's probably going to have a very different reaction from your consumers. So you want to be aware of all that. Now, when it comes to infringement of it, whenever you're sending something and it is just voluntary, like a cease and desist letter, you're really asking for voluntary participation. Lots of times you receive a cease and desist, or you send one and you say, well, they didn't stop yet. And I know certainly clients have reached out and they're like, we sent the cease and desist and I'm on their Instagram and they're still using it, because it's just the first step. And people can voluntarily just say, hey, I don't want the time, the trouble, the expense of litigation if that's going to go forward. So I want to stop using their brand. But, you have to be aware that it may not completely stop the action, or there may be further negotiations and ways that you are trying to enforce it that you go forward with. But usually if you send a cease and desist and could get some sort of settlement or agreement from them as far as how you guys will proceed, that can be a lot easier of a route to enforce from a litigation or secondary action perspective.
And likewise, when you're on the receiving end of a cease and desist letter, 9 times out of 10, if you're going to have some sort of trademark infringement lawsuit, a cease and desist letter was sent before a lawsuit was filed. And that's not 100%, but majority of the time, the cease and desist letter is sent first, and the lawsuit is filed because the person has not stopped, or they haven't come to some sort of resolution. So I will say this: if you receive a cease and desist letter, reach out to legal counsel. Sometimes our clients who ended up hiring us for the lawsuit say, I received it, but I didn't think it was real. I thought it was some sort of scam. You can always reach out to an attorney's office for a consult and say, hey, I received this. I just want to know if it has any sort of legal, reasoning or meaning behind it. Is this real, or is this some sort of solicitation or scam? And most attorneys are willing, to tell you like, hey, you need to take this seriously, or no, this is some sort of solicitation.
Yeah.
So take it seriously, because at least in a couple of our cases right now, I feel like if they would have just responded to the cease and desist letter, they may have had an option to enter into a better negotiating period than the point of them being in the lawsuit now, where we're representing them.
So when it comes to what you can do, she already mentioned the Amazon brand registry. Lots of times now they're making it a precursor. So when you're going through your application and trying to get your product on Amazon, they want to see some proof that you've taken the first steps in protecting that trademark, and at least are conscious that that is something that has repercussions, something they don't want to be involved with the legal repercussions for. And there also, it gives you a certain amount of power when it comes to domains, because you may not have been the first to it. And we certainly know there were companies that originally went out and grabbed lots of domains, like whatever sounded cool. I like domains too. So I often grab domains. I'm like, that's a good idea, even though I haven't vetted it out. But it is a way to protect your brand. And for many people, your website is the first thing that someone's going to check. It's the first way to verify, get to know your business. They're going to go and find it if they have an interest or refer to your business. And so you can submit for that to be removed if you properly own a trademark. Social media, Rena, if you want to cover that part. I'm not sure exactly what they will do for taking down a trademark.
Yeah, so each platform has its own process and method for reporting and removing items that are deemed to be trademark infringement. For example, TikTok, Instagram, and Facebook all have trademark infringement forms that you can fill in similar to like a Google Doc, and it sends to their specific legal department. It will ask you to upload your specific trademark registration certificate. It'll give you the option to put in the URL of the page or the specific posts that you believe are infringing on your specific trademark. And it can also give you the option to have specific tag names removed. So like there's someone's handle on Instagram or someone's handle on Facebook. If they are offering the same services or products you are, then you can request them to have that page taken down. And so in one of our former cases that we actually got closed out finally a couple months ago for a client, they didn't have the entire page taken down, but they had certain posts removed because Meta said, hey, we received a complaint that this is infringing on someone's trademark. Based on the proof that's provided, we believe that it is, and they removed those specific posts. In other instances, I had a client who received a cease and desist letter. They didn't think anything of it. They didn't answer. So opposing party said, oh, you're not taking us seriously. We're going to show you how serious we are. They reached out to Facebook and Instagram, and their entire business pages were taken down.
Yeah.
My client was highly upset because this is my main source of clientele. I get my clients mainly through Facebook and Instagram, or maybe it's TikTok for you. And those pages are completely removed. All their followers are gone. Their build up, it's all gone because they didn't answer the cease and desist letter. And because the other party had a trademark registration on file with the USPTO, they just had to show proof, right? For the domain name removal, if someone is using that domain name for the products or services that your trademark is registered for, you can reach out to the organization ICANN, and they will actually take down your website. You'll go to your URL and it'll say page cannot be found, right? And that's only if they're using it for the specific products or services that are on your registration, because you could have a trademark and someone else could have a trademark for the same name, but y'all are in different industries.
Yes.
So those are the things that we're talking about. These are real, they happen. And if it happens to you, like it can be life shattering for your business, because a lot of people heavily promote and heavily produce sales through social media these days. And the case that I'm talking about, we closed out a few months ago. One of the damages that our client was saying was that we don't have access to the social media page. And that was the main way that we were promoting this service, you know, and so we're being restricted from that. And those are damages they were trying to claim in the actual lawsuit.
And that was devastating because it takes months, sometimes years, to build 50,000 followers, 60,000 followers, and to go down where it's white. And I will tell you that negotiating for them to reinstate your account can be very difficult. It's not just a number you can call. You know, they have their own processes, but it's very standoffish. When they make a final decision, they won't communicate with you about it anymore. And so now you're not only without the brand name, you're starting from zero, which can be very frustrating. And then it also leads to clientele distrust, because, hey, I was working with this one company. Now you're saying you're the same. I don't know if you're the same, you're different, or the original trademark company is the right one. And when people are confused, you know, just the way our brains work is just get out of the confusion, go away and do something different. So when people are confused, often they just abandon ship and go do something different, which can be a serious disruption in your business operations.
Yeah. And for the person who's actually the trademark holder, this is a fast and low cost way to enforce your rights, because it's, like I said, this form that you're filling out to report the infringement, it's similar to like a Google Doc form. You're just popping in the information. It's nothing expansive that you're doing, but it can show other companies that you mean business, and they should not be trying to mess with your brand when you have taken the steps to get the protection to enforce those rights.
Okay, so here's the super not fun part. When a lawsuit is necessary, either because someone is infringing on your trademark, or oops, you've been caught, you have been the infringer, and you've gotten served from legal documents after you've received and maybe ignored a cease and desist. So someone can say in the course of litigation, and so like I said, cease and desist is voluntary. People participate because they want to avoid this next step. Participating or failure to participate in a lawsuit means you lose. It doesn't mean that the court just says, oh shucks, they didn't want to answer. They're going to proceed with the default against you. So failure to respond in this part or failure to participate, it gives a bad result automatically. So you do want, your ears will perk up usually when you get served or the service processor knocks on your door. But they can do a lot of things once that suit is open. They can file an injunction, which is a request for immediate relief. Hey, make them stop right now. It's causing a dip in my business. Or even, I can measure this dip in my business or this confusion that this alternative business name is causing, and I want them to pay what they have made me lose in my business in a monetary amount. So they can just say stop business operations or stop marketing or stop using a domain or a website, or they can say you owe me, because for every month that you're operating under that business name, you're taking funds, clients, business out of my business reach. Mm-hmm. So they're going to be, because you're usually going to have an attorney, and if it is your business that owns a trademark, unfortunately for businesses, or fortunately, it depends on how you look at it, you cannot be pro se, meaning you cannot represent yourself. You have to have that entity, the LLC or the name of the business, a corporation, a LP, whatever it is, has to be represented by an attorney. So self-representation is only an option if you have registered that trademark in your personal name. Any other registration means you have to get counsel. So you have legal fees, you have the uncertainty of if you're going to win or if you're going to lose. And all of those can be very realistic concerns. Now, the cost is better on the other end because the federal laws regarding trademark infringement are pretty set in stone. If you are infringing on someone's trademark, especially if you're doing it knowingly, meaning you got the cease and desist and failed to respond or just said it's not important, I'm going to ignore it, then there's some very real penalties that are judged based off of the productivity of your business. So you could say, hey, they have that brand and they only make $100 a month and I make $100,000 a month. That's a bad thing because they're deeming their valuation of that lawsuit on your operations. So don't just think that, hey, I looked at their Instagram, they have 2 followers, they barely do business, and it's not a risk to you. It is a very big risk, especially as your business becomes successful.
And to speak to that, there are certain organizations who may not even promote heavily on Instagram. They only have 2 followers. You go to LinkedIn and they have 20,000 followers, mm-hmm. right? Their base isn't necessarily where your base is. If they're telling you they have a registered trademark certificate, you're able to verify that with the USPTO. Take it seriously. Don't take it lightly. And I would say I think it's cool as a lawyer, but the other cool thing about the lawsuit option when it comes to trademarks is at the point where you have initiated a lawsuit, you can enforce what are called common law trademark rights. And that's when you don't actually have an actual registration for something such as your persona, but you can tell people that, hey, you cannot use my face or my body to be able to promote your specific products or your services. The very popular case is someone was using in a commercial Vanna White's persona, right? It wasn't actually like Vanna White, but it was the persona of Vanna White, and they're using it to advertise their specific products or services on a commercial, and that was deemed to be infringing on her common law rights, right? She did not give permission for her persona to be used for someone to advertise or market their specific services or products. And y'all may not want to hear about Sean Combs right now, but years ago he had Sean John and he had sold the rights to the name. However, he did not ever sell the rights for someone to advertise the name with his actual face. And so there was a trademark infringement lawsuit because when it kind of restarted recently, a few years ago, they put his face connected to it. And he said, I didn't give you those rights. Mm-hmm. The only rights you had were to use the name. And so that was a reason for him to be able to start the trademark infringement lawsuit. So real life success stories. I think that we did a great job scaring you and kind of talking to you about how to enforce the brand and what can happen with lawsuits and cease and desist letters and takedowns. But there are actual success stories if you're the person who is trying to enforce your rights or stand up for your rights. And so part of that is what can you handle alone? Like, when do you actually need to call us? So we saw some people in the comments talking about the monitoring service, and they were like, that's a great idea, just to actually go through and start looking for myself to see if I see any names out there. That's something 100% you can do on your own. Or like we said, there are companies that you can hire to be able to do the monitoring services for you. But when you want to call us, when do you think that they should start to reach out?
Well, I mean, I think I've learned as a business owner, just because you can do it doesn't mean you will do it, and it doesn't mean that it's a good use of your time. So just because it's accessible to you, and hey, I could go and register and look every 2 or 3 months, just be honest with yourself. If you're not going to do it, it is a valuable asset, especially if you've taken the time to get it registered. And so when you assess what you can do, anytime it steps outside of what you can do or want to do, that's probably when you should give us a call. But certainly, if you get a cease and desist letter, even if you think it might be basura, some of that may be DIY. You can go to the USPTO office and do your own search. But there are also common law trademarks, and vetting the difference between what's real and what's not can be difficult. So I would encourage you to do a consultation with an attorney. And it may sound like, oh my God, I don't want to pay for their time, but having that peace of mind, knowing you can go forward and continue to build your brand, is priceless. So spending $300-$400 to have an hour-long consultation with attorneys taking their time and giving you some peace of mind is a good investment in your business. So a lot of times we think about work for your business as an expense, but it's an investment in your growth, in your brand's ability to grow, in your ability to sell it as a real asset. And so unfortunately, investing in things do cost money, but it can be completely worth the return for that.
Yeah, so especially if you're experiencing repeat infringers, people are not listening to a cease and desist letter that you sent out on your own. You need to seek legal counsel. If you've received a formal cease and desist letter, seek legal counsel. Yeah. If you're looking to file a federal trademark application, seek legal counsel. The people who are reviewing those trademark applications are licensed attorneys. And when they tell you that they have a question about your application or something is wrong with your application, they are citing actual case law and federal statutes. Mm-hmm. And that can be very hard to understand for just, a layperson who may not have the legal background or knowledge. And definitely when you're preparing for litigation, you want to reach out to counsel. And as Eleanor stated, if you're being sued in the name of the business, you have to have legal counsel. You cannot represent yourself. You cannot be pro se, as it's called. So really think about what she said, the cost versus risk breakdown. If I've invested this much time into building up my brand, it seems like I should invest, the same amount of money or even more money or time to be able to protect it. So we'll see if there are any more questions. I know that someone did say that they wanted to start searching. They thought that was a great idea. But if you have any other questions, feel free to pop them in. We'll stay in for an extra minute or two. But if you're viewing this after the live has ended, you can feel free to send questions directly to me. My firm email address is stated on the screen. And we would love to be able to answer those questions for you. That's if you have one question. If you have a series of questions, we need to set up a call.
Yeah. You know what I think would be a good thing for people, just to go back to the basics on trademarking. What's the difference in the categories and services? Because that can be confusing. You say have a trademark. And I remember reading a case about Dairy Queen, as a food brand and a big food brand. Most people know Dairy Queen, and how they lost an infringement case on a different service or category because they said they shouldn't be confused. If they're going to DQ for a shake or a slurry, whatever they call it, then you have something completely different. So maybe a little bit of information on categories versus different categories and services.
And this sounds like a great topic for another webinar.
It does.
Yeah.
It does.
So when you're submitting a trademark application or trying to enforce your trademark rights, one thing that I did talk about is making sure that the services or products that the other party is offering are the same or similar to what you're offering. So for example, there is a name Delta. And a lot of people know Delta Airlines. Delta is trademarked as it pertains to airline services and things of that nature. But Delta is also trademarked by an insurance company, and they offer dental insurance. And so this is an example.
And don't they also have Delta products for like sinks and faucets and stuff?
They may. Yeah. She would know in the real estate, right? And doing all your flips and things like that and renovating. So this is a great example of how one name could be trademarked by 3 or 4 different entities, but they are in different types of industries. And so when we submit the trademark application specifically asks for the types, and we have to be very specific with the specific services and products that you want protection as it relates to this name for. And that's where we get into the term class. So the trademark office uses the term class, almost short for classification, to be able to classify the exact services you offer and the exact products you offer to your specific trademark. A trademark is not a broad protection, meaning you can just stop anybody who's using the name. It's very specific in the instance that they're only going to enforce it for the specific services or products that you put on that application that your brand offers. So if we were to trademark the name, Curry Law Firm for law firm services, we couldn't try to file a trademark infringement suit for Curry Tire Services, down the street. Like those are just two completely different industries. And when we submitted that application and we had to specify the classes that we wanted that trademark to apply to, we would have put legal services, right? They would have put tire services or tire retail services. And so those are the things that are important and can really determine if you actually have a good case for trademark infringement, right? Because someone else may be utilizing the name, but not in an infringing way. It doesn't affect your business. It doesn't affect your sales. It's not in the same industry at all.
Yeah. And so I think that's such important information, because that's where getting involved with an attorney really helps give you some clarity and gives you the protection that you're thinking for. Maybe I need additional classes or services if I want to protect additional lines of business that I intend to expand to. And so if not, you're starting from scratch, new applications every time you want to do an expansion to your business. So it's something to be super mindful for. And then the last thing I wanted to say was just to follow up on the LLC question. So lots of times people say, I searched Texas Secretary of State and I didn't see anything else. One, the points of distinction are very easy for the Secretary of State. I could have a Curry Law Services, a Curry Law and investment services. So I can just, with different points of distinction, get an LLC, and they can be very small. I can just be adding a different name to the end, and now I have a point of distinction. And it is only a state search. So USPTO is a federal search, but you can have a Curry Law Firm in every state of America, and it doesn't do anything to any one of them, right? And so that may be a problem for me if I plan to take my Curry Law Firm to a state that already has a Curry Law Firm, especially if they have a trademark. So just know that the problem may not be now. You may surprise yourself in your little hometown business. Martha Stewart made plants for people or made little baskets for people, right? So who would know she would be an international brand? So don't sell your business short by under investing in things that are important to its growth.
So thank you all so much for attending. If you take away anything from today, protect your brand. That means you're protecting your future. If you are in need of our services or representation, please feel free to reach out to our office. Our office number, website, email address are listed here. We would love to help you. We would love to be able to set up a consult to be able to kind of talk to you about what your legal options are and provide some more clarity. I think that as attorneys, one of the top jobs we have isn't just to advocate, isn't just to be able to walk into a courtroom, but it is to educate, to be able to educate a lay person or an everyday ordinary person on what the laws are and how they apply to your specific situation, how can they be used to help you, and what can be done if you don't follow them. So we thank you so much for joining today. We definitely hope you found this information valuable. Please be on the lookout on our YouTube page, Curry Law Firm, for lots of other videos covering a variety of different topics such as trust, wills, litigation, adverse possession, and please, if you guys want more information on different topics, let us know, and we would love to host a webinar to talk about those specific topics.
Make sure to like, share, and subscribe if you go to any of our social media pages or our YouTube page.
All right, have a great day.